in Australia. So I welcome you to the first webinar for our book launch, sorry for the pronunciation, for our book. The book is titled International Economic Law, Southern African Perspectives and Priority. My name is Franziska Sucker, and I had the extremely great pleasure to co-edit a book together with the incredible Kholofelo Kugler, a friend and colleague of mine. And we had a great assistant, Kolisi Ngulube, whom you will not see today, but in the webinar too, who joined us as an assistant editor around about this year, last time, August. It was an incredible, valuable addition. And the three of us are very excited that this project came to a conclusion now. It was a very long journey, and it's the first part of our project that came to an end after very long nights and discussions, and sometimes waking up in the morning, not being part of a WhatsApp chat and seeing 100 missed messages, not possible to catch up. And so it was a pleasure to work with both of you, and it would have not been completed if either of you were missing. So I was very grateful for that team. A quick background to the book, really very quick, is what is the purpose? What did we wanted to achieve? We wanted to address a gap in literature, and that meant to address topics in international economic law that are of priority for Southern African countries, and would we say something so, that are most relevant for the continent and are told from maybe a little bit of a different perspective than in the existing books. So we, of course, did not want to reinvent WTO law, international economic law, because the rules are the rules. But we aimed of using examples from regional courts, using examples that are most relevant for African countries, providing maybe different options of an interpretation of WTO law with different perspectives, different meaning, illustrating effect of WTO provisions within domestic systems in Africa. And we think the first book does that. We think that it might provide now a deeper understanding of those priorities for Africa with those chapters. It could provide a reference book as a starting point for deeper research, depending on the topic. It does provide an overview about Southern African, how Southern Africa fits into the broader regulatory framework, and we think it does that. Why did we add the brackets around Southern? That is a question I received a couple of times already. First of all, we actually preferred a different title of the book. That was a long discussion between the publisher and us. The publisher had strategic reasons for changing it a bit. We would have preferred priorities. No, what was the last? Southern African priorities and perspectives in international economic law. But we were pushed to put international economic law on the front. Southern is, for different reasons, the focus is on Southern Africa, right? Most chapters are focusing on the Southern African region, but not all. And there are 6, I think, I put it down, no, 9 even. 9 of the 16 authors are South Africans. So that is already a big focus of the book. But 14 of the 16 authors are African born. So others have added a tremendous perspective, enriched the book, and we didn't want to include that. And we are also aware that Africa is not a one size fits all, but African countries share experiences, and so you can draw parallels. So we wanted to include Africa, but still be clear about the focus of the Southern African region for now, and that's why we expanded the geographical focus and hope that that worked out. It was very important to us that the majority is African-born. There are 2 people, including myself, that are not, but at least the 2 people have lived very long on the continent to understand it a bit better than outside. It was important to us to give that grounding to the book and to show the experience that Africans have in international economic law and show the knowledge in that field. We have now, and we are very proud of that, a mixture of very young, talented African voices in the book, together with some established scholars, government officials, and practitioners, a very diverse authorship. And we are deeply grateful to the authors and for their contributions, because they actually made the book possible. We have divided the book into 4 main categories. A background part, where we address first the priorities that Southern Africa has and try to categorize them a bit. We address South African trade policy in the 90s, where we will hear Leora Blumberg today on it, which is a great pleasure. We have South Africa's international economic relations, addressed also today by Asmita. We did have in the book the dispute settlement and the participation of African countries. We discussed differential treatment, which is, of course, of utmost importance, will also be addressed today by Regis Simo. We addressed the AFCFTA. We discuss anti-dumping, which is critical for Africa. We address safeguards and subsidies, which are other trade remedies. We're going into agricultural subsidies in the book, the SPS agreement, trade facilitation, and even trade and competition, and end off with investment. And if you hear that list, that's of course not all aspects that international economic law would ever encompass. There are a lot of gaps, not to speak of a TBT, which is the most obvious when you have an SPS chapter, but also others. And that we decided, because it was such a long journey, to kind of be also realistic about it. What can we do now, and where do we have to at first finish a part and then continue? So
okay,
the vision is shared by Kholo and by Kolisi. So we will continue this project with further priorities, far more detailed. Of course, for example, TBT, we will have to address public health. We want to address things like informal cross-border trading that are extremely important, digital trade, and so on. That is not the topic of today, but just to let you all know already that this is the beginning, and I think that conversation has to continue and will continue, and we will make sure that it does. I will now hand over to Kholo, my incredible co-author, and I cannot thank you enough, Kholo. Thank you so much.
Thank you so much, Fran, and thank you for inviting me onto this project. And I won't keep you very long, but this has been a very long and arduous journey. I can tell you that when we started this project, I didn't have children, and now I have one and one coming. So you can imagine that it's been a very important part of my family as well. All right, so before we get started with, very esteemed panelists, I just want to give you, introduce them to you and then let them start. It really is a pleasure, first of all, to introduce a man that needs no introduction, the Honorable Justice David Unterhalter, who will deliver the keynote speech. He's currently a judge of the High Court, and he's acted in various capacities in different courts, like the High Court, the Competition Appeal Court, and he's also acting as a Supreme Court of Appeal Justice. He was an advocate in South Africa, the Johannesburg Bar from 1990 until 2017. He was also called to the English Bar from 2009 to 2017. He was the first South African also member of the appellate body, and he was a chair from 2010 to 2011. He was the appellate body member from 2007 to 2013. He was also professor of law at the University of the Witwatersrand, and he was also the director of the Mandela Institute, who is organizing this event today. And also he has recently been nominated for a spot in the Constitutional Court of South Africa. So really wish him luck, and we hope that he can get that prestigious appointment. Next, we have Leora Blumberg, who is currently a member of the Anti-Dumping Review Panel in Australia. Leora was a part at Weber Wenzel, which is still one of the biggest and best firms in South Africa. And before that, and after that, she served as a deputy chairperson of the South African Boards on Tariff and Trade, which is now ITAC, from 1996 to 2000, June 2000. And during that time, she was involved in restructuring South Africa's trade remedy system and also involved in trade negotiations on behalf of the South African government at that very sort of important juncture. She also lectured at Wits and Cape Town and at various other universities on WTO law. She's been a panelist in many, many WTO disputes and is currently serving as a chairperson in her 9th WTO panel, and is actually one of the people that has been a panelist in the most number of disputes at the WTO, which is really, really impressive. And she, as I said to you, was involved very much in sort of shaping what is now South Africa's, or laying the groundwork of South Africa's at least anti-dumping or trade remedies disciplines, which we'll talk about. Very interesting when we have her segment. Secondly, we have Mrs. Asmita Parshotam, who is a dear friend of mine and is also an international trade and development expert. And she is an admitted attorney of the High Court of South Africa, although she's defected. She's no longer a lawyer. She's now strictly into policy. She was previously a researcher at SAIA, and she's also worked at the European Center of Development Policy Management in Maastricht in the Netherlands. And she was a trainee at the SPS division of the WTO. Last but not least, we have Dr. Regis Simo, who is a senior researcher at the Mandela Institute at Wits. He teaches and writes on international economic law, especially WTO law, law and development, and African regional integration. He's a contributing editor of Afronomics Law blog. If you have not checked that out, please do. It is really one of the leading blogs or sources of information for at least southern or south to south, economic law relations, just really broad issues and really, really good. And is also an editorial member of the International Journal of Public Law and Policy and the African Journal of International Economic Law. So we really have a very, very prestigious and esteemed panel. But before I take away any time from our keynote speaker, I would like to invite the Honorable Justice Unterhalter to please share a few words with us.
Well, thank you very much for inviting me to speak, and to Kolo and Fran as the editors of this project. Great congratulations to you in pulling these things together. I know how difficult they are and how recalcitrant many authors are. So well done. It looks like a really first-class collection of essays with different and distinctive voices from the continent speaking on very important themes that are not just of domestic or even continental relevance, but ultimately relevance to the international trading system at large. And I have little doubt that the book and the voices that are represented there will be heard in many places. And so a great congratulations to you as the editors for bringing this project to fruition. In my introductory remarks, I wanted to say a few things about how the international trading system and international economic law is at a crossroads, and where I think there might be different directions that the world might take from this point, and then have some reflections about where Africa at large, and to some degree our region, sits in relation to some of these questions. And I will try and stick, because I know Fran is very sensibly a stickler for time, to my allotted 10 minutes. The reason that I say that we are at a crossroads is that there are very large forces driving through the world at the moment that are entirely novel and distinctive. And I think you can see them reflected in a whole variety of ways. Let me begin firstly with the pandemic that we've been living through for the last 2 years. You might have thought that if anything would bind together the world in a coordinated effort to deal with a phenomenon that cannot be solved but on a global basis, that it would be the COVID pandemic. But actually quite the reverse has been demonstrated by this catastrophe for the world. Catastrophe in personal terms, in economic terms, in national and international terms. The WHO is just an organization for contestation, and its ability to coordinate an international and global response has simply not materialized, not because there aren't many people who would will it to do so, but because it is just another international institution that is reflective of broader themes of national interest, regional interests, and ultimately, I'm sorry to say, global power rivalry. It's not just COVID, which possibly you might have thought took us by surprise, and perhaps where the responses to it would not necessarily be the best indication of where the global order might be heading. But I think you can see it very well reflected in other areas, and some of them are very close to the trade world, which we are all extremely interested in. But if you look at the problem from a very sort of, dare I say it, global perspective, we have moved since the 1990s from, as often remarked, a unipolar world in which the United States stood as sometimes a much resented, but sometimes a necessary part of the global order, to a global order that is not just multipolar, but is increasingly starting to look like a world dominated by a particular rivalry between the US and its allies and China and those who fall within that orbit. And I think the big question, and it's particularly a question for Africa, is in the context of that global rivalry, what will happen to the aspirations for a rule-based order in which so many problems, not just of our continent, but ultimately of the world, can only be solved through global coordination? And so we have, on the one hand, an intense reversion to a form of national sovereignty and the assertion of global rivalry by major powers. And on the other hand, we see time and time again that there are fundamental issues that simply are incapable of solution without some of the loftier aspirations of global ordering and supranational cooperation that had formed part of a world that we became accustomed to, but which we are seeing in many, many forms falling apart. It's obvious to everybody that the great crisis of our time is climate change. And we're going into a critical meeting in November in Glasgow to see what commitments the world can actually make to a challenge that is going to affect every aspect of everyone's life on the planet. But we already see that while there are many imperatives that push countries towards cooperation, there are as many responses which pull them apart. And the possibility of catastrophe, not to put too fine a point on it, is actually staring us in the face. The problem is that the climate crisis unfolds by degrees. It isn't actually even like the pandemic. It doesn't suddenly start killing people. It just begins to tear apart the economic systems that we have been accustomed to. So we have, as I've said, these imperatives towards collaboration and some recognition that that is an absolute necessity. But we have many, many forces at work which pull in the opposite direction. Let me mention lastly, in relation to these difficulties, the WTO, which many on this webinar have had all kinds of connections to, and which, speaking for myself, I still consider to be an institution of fundamental importance. But it is itself reflective of breakdown, not simply in the dispute settlement system, which has been dealt a grievous blow by reason of the appellate body no longer being able to function because of the disaffection of the United States, but because that crisis has been a long time coming through the failure to actually advance trade negotiation agendas and bring the WTO up into an age where many different kinds of trade issues need treatment through rules and multilateral answers. And again, I think it's genuinely an open question as to whether the WTO is really going to survive, as it should, and I would hope must, but it's by no means certain that it can, in the face of these forces that are at work. That brings me to the centrality of what does Africa, Southern Africa, and South Africa do about this? Well, there are green shoots of some importance. I mean, no one who is not paying attention can but behold the African Continental Free Trade Agreement. It is enormously ambitious in its aspirations, and it is vitally important to redress the historical patterns of colonial trade effectively. And there's much that can be done that would be extraordinarily productive for economic growth and welfare in Africa. But will we as Africans actually succeed in this ambitious venture? Well, again, we are as much prey to domestic imperatives and the assertions of national sovereignty and the appearance of solidarity without its reality. And again, if we cannot make this ambitious project a success so that it could come to resemble some of the successes, for example, that the European Union has ultimately achieved, well, it will be another great project that doesn't reach its potential. But it has enormous potential, and we should all be lending our efforts in different ways to its success, because if Africa, with its enormous potential, can speak with a voice and become more of an economic force in the world and not simply a continent of bits and pieces, which represents a tiny fraction of trade that everyone pretends to pay attention to, but actually it isn't significant. We've got to change that. And the only way of changing that is to show that we can count, do count, that we can talk with a voice that matters in international affairs, and that we will engage in some of these difficult projects, not just continentally, but multilaterally, to try not simply to advance our own agendas, but to advance some of these supranational multilateral agendas. And let me then come back to our region and to South Africa. We, of course, have one of the oldest customs unions in the world, but it is dominated by old forms where South Africa effectively is so overwhelmingly dominant economically and operates a form of fund transfer through the region that it isn't actually an association that itself has reached any of its local and domestic potential. And South Africa itself, sadly, has been a country that for more than a decade has become so inwardly turning upon itself and its own domestic problems that we no longer speak as an interlocutor in the world. There was a time in the 90s where South Africa was a critical interlocutor between important parts of the global trading system, and we relished that role and took it up with enthusiasm and were used in that way, in a very productive way. We're now largely discounted because our foreign policy is shambolic and our efforts to make sensible interventions are so often simply not credible. So I hope that we change that South Africa becomes an important collaborative force in the continent and with the extraordinary importance of this continental free trade agreement. And there are signs that we mean to take that seriously, and that the government that now governs is more concerned and more connected to these projects. And similarly with multilateral agendas. But we have to move ourselves away from narrow parochialism, from this endlessly internal debate about how to pursue modest goals. We have to have ambition. We have to see the potential for integrating ourselves into the continent. We have to see our potential for reasserting the importance of multilateralism and making it gel with our regional aspirations. And we need to be ambitious in all of those kinds of ways, which I fear for at least 10 years or more, we have simply not done. So this book is a way of rejoining those debates, raising our voices, making them heard, and asserting the importance of some of the values that matter for the welfare not just of African people at large, but ultimately in resolving many of the most difficult issues of the day that require extraordinary foresight and ambition in forging together countries and organizations which are in some respects so often pulling themselves apart to the great detriment of the global good, which I think ultimately we have to both face and ultimately try to pursue in different ways. So with that, my congratulations again, and I hope the book, as it truly deserves to be, will be an enormous success, well read, well understood, and influential in the debates that presently exist and are still to come. Thank you very much.
Thank you very much, Justice Unterhalter, and thank you so much for your comments, which have really set the stage very well for today's conversation, where we sort of centralize South Africa as a player, not only in the Southern African region, of course, but also in the broader African context and globally as well, but also talk about things that are very important to Africa and, of course, the Southern African region, which is development. And so, so the format of the next part of our, the main part of our webinar is actually talking to the authors. And I think this is a great opportunity to kind of hear their perspectives, in words, and of course you will read them in the book themselves. But we will first start with Leora Blumberg, who's written a very sort of personal, but also very important chapter to sort of center the book and just talk to us how South Africa got re-engaged into the multilateral trading system after, as you know, being a global pariah for many, many years, excluded and sanctioned. And Leora played a very important role in sort of negotiating South Africa's re-entry into the multilateral trading system. So the format of this part of the webinar will be that the authors will summarize, sort of highlights of the chapters in about a minute or two, and then we'll have a Q&A discussion with the author. If you have any questions at any time, please do not hesitate to put it in the chat box. We'll either ask the author as they come if we find that they're relevant, or keep them for the end. So Leora, please can you just give us an overview of your chapter, and then we'll go into Q&A. Leora, we seem to have lost you. Can you try again?
She needs to unmute.
Maybe you're muted?
No. Oh, gosh.
Yes, we hear you.
Yeah.
Go ahead, yes, go ahead, yeah.
I said, which you probably didn't hear, how delighted I am to participate in this webinar. I fortuitously crossed paths with Kholo, one of the editors of the book, in February 2020, just before the world was thrust into pandemic chaos. We enjoyed a coffee in the atrium of the World Trade Organization in Geneva, and it was a couple of weeks later that I was invited as a latecomer to participate in this outstanding project. Writing and relive that extraordinary and most exciting decade for Southern African trade. I begin the chapter with a short historical perspective of trade protectionism in South Africa. South Africa followed a policy of import replacement since 1922, supported by high tariff protection, quantitative import restrictions, and import surcharges. And it was only in the early 90s that South Africa started to emerge from its political and economic isolation, and its protectionist trade policies were placed under the GATT spotlight, just as the Uruguay round roared into gear. Against this background, I discussed the Uruguay round negotiations with South Africa coming under increasing pressure to liberalize its trade policies by its main trading partners, particularly the then European Community and the US, who pressurized South Africa to improve their tariff offer and liberalize at a faster rate. In addition to this external pressure to liberalize, South Africa itself recognized that a change in direction towards export-led industrial development and economic growth was of critical importance. I discussed South Africa's preparation for the new era of world trade as it emerged from its inward focus and the general lack of knowledge, skills, experience, and expertise in international trade and the rule-based multilateral trading system. In the mid-1980s, South Africa embarked on an extraordinary mission to acquire knowledge and expertise and build capacity in all areas of international trade in preparation for its grand entry into the WTO and the global trade environment. I discussed the increasing use of trade remedies as South African industries braced themselves for the potential flood of highly competitive imports. And while promoting the policy of less protection, the South African government had to assure local producers that an effective anti-dumping system would be introduced as a safety net to protect imports. The government undertook to restructure South Africa's anti-dumping laws and institutions in accordance with WTO rules and international standards. There was a major increase in the use of anti-dumping instruments in South Africa for the rest of the decade. And in fact, by the end of 1999, South Africa became the third largest WTO member user of the anti-dumping mechanism. And that was after the European Union and the US, which is quite an astonishing statistic given the relative small size of the South African economy compared to the EU and the US, and the latter having been using the instrument vigorously for decades. There was also increasing focus by member states to ensure South Africa moved towards greater compliance with the WTO rules. I also discussed the deliberate shift in the 1990s from import replacement towards export orientation, initiated by the apartheid government and embraced by the ANC when it came to power in 1994, who put forth an economic policy framework which promoted trade liberalization. It was generally agreed that export-led economic growth was of critical importance for South Africa and entry or re-entry into the international markets. At the same time, it was recognized that it was essential to concurrently address the so-called anti-export bias. There was new emphasis on bilateral and regional trade groupings, which offered South African exports preferential access to markets. South Africa benefited from the unique position of having characteristics of both developing and developed country aspects of its economy and the goodwill generated by South Africa's political transition. New market access opportunities also brought increased exposure for South African exports to other restrictive trade practices and non-tariff barriers obstructing market access, including other WTO members' own robust use or misuse of trade remedies and other permitted WTO tools such as safeguards, technical barriers to trade, and sanitary and phytosanitary measures. The South African government, industries, and companies involved in international trade needed to acquire the skills and expertise to recognize and deal more effectively with these trade practices. I discussed the policy of the new government to build closer relations with its Southern African neighbors after years of destabilization and strained relations, making Southern Africa a top priority. The most important preferential trade relationship for South Africa was the SACU, and there was a focus on its renegotiation. South Africa also became a member of the Southern African Development Community in 1994, which passed its protocol on trade in August 1996. South Africa also concluded or renegotiated bilateral trade agreements with some neighboring countries. Major developed nations also sought to renew and strengthen political and trading ties with South Africa, now regarded as the economic powerhouse of and the springboard into Southern Africa. The EU was first in line in the late 1990s when South Africa began negotiating a bilateral agreement for trade and development with the EU, which eventually culminated in the conclusion of the Trade Development and Cooperation Agreement in 1999, and that entered into force in 2004. The 1990s was an exciting time for South Africa from all perspectives, with changing international relations and its complicated and dynamic transformation in the political, economic, and social spheres. The time was especially interesting from an international trade policy perspective, as it coincided with major global changes in the form of the finalization of the Uruguay round and the establishment of the WTO and the rule-based system. South Africa transformed from pariah status in economic isolation to being the trade flavor of the decade and the perceived launching pad into Southern Africa. South Africa embraced the trade challenges of the decade, and by the end of the decade, transformed into a fully fledged, sophisticated, and skillful participant in the global trade arena, and was poised to take on greater leadership roles in the global trading system, ready for the new trade challenges and opportunities that the 21st century would undoubtedly bring. Thank you.
Thank you very much, Leora, for actually a comprehensive summary of your chapter. And you've actually addressed a lot of the questions that I had, but I think sort of, front in my mind was, because, you were involved sort of in the background, what type of internal organization and discussion and maybe stakeholder sort of participation happened in those days, especially in the run-up to the election? So we have a regime that is, coming to an end, and we have a political party that is anticipating taking power of an economy that you said is very much sort of a dual type of economy, where aspects of it is developing, large aspects, and the other aspect is developed. So what type of conversations were had, and what was the thinking, if there was even sort of a common thinking of how South Africa would engage economically, not only sort of domestically, but obviously externally? So maybe if you can just talk us through those internal functionings of how these negotiations worked.
Oh, well, it was very interesting because the negotiations with the Uruguay round, when they started, was with the apartheid government. But it was becoming clear as the critical stage, the Uruguay round negotiations were 8 years. So it was in the 1990s, just as South Africa was transforming. Mandela had been released from prison, and it was clear that there was going to be a political transition. So while South Africa, the government was negotiating, the previous government was negotiating formally with its trading partners. It was really interesting because there were consultations at the same time, because it was accepted that when the Uruguay round was completed, it would be a new democratic government. So they did consult. There were many consultations in the negotiating stages of the Uruguay round with different stakeholders, but the ANC was involved in that, and obviously business and all parties. But it was a very interesting that when the consultation process included the ANC economic department in many instances, and even at the time when companies and industries were preparing and negotiating, each time the trading partners came back and requested a better offer by South Africa, and the industries would be consulted, and all the different stakeholders. So there was a great deal of cooperation during the period leading up to the signing of the negotiation, the Uruguay round, because when it actually came into effect and South Africa entered into the WTO, it was with the new government. And even during that time, there were continuous negotiations with all parties. You remember there was a National Economic Forum, and it changed into different bodies, but there was always a great deal of consultation between parties. Sometimes it took for anything to be done. It had to go through all these various processes. Of course, during those times, I wasn't prior to the finalization of the Uruguay round. I was in private practice at Weber Wenzel. It was only afterwards I was in government. But interestingly enough, was still involved with some of those interactions prior to the finalization of the Uruguay round.
Thanks, Leora. Unfortunately, we're so pressed for time, but there's so many questions and so many things that we can discuss about this. I mean, just for context and for those who don't know, the Uruguay round the negotiations ended in 1994. So obviously this is the time when South Africa actually, had the first democratic elections, and the WTO, opened its doors on the 1st of January, 1995. So, I mean, the background of this negotiations is, huge political upheaval in the country. And it's just sort of amazing as to what was done and what was decided. And one of the criticisms that, and maybe Reggie, you can address that, or even Leora, if you want to quickly, was that the previous regime really liberalized and made offers, that were sort of similar to developed countries, whereas the country wasn't really ready to liberalize to that extent. And does this feed into South Africa's use of trade remedies, especially anti-dumping at that time? Or do you think, there's other explanatory forces or factors behind, the type of liberalization and the use of trade remedies as a tool?
Well, interestingly enough, when South Africa joined the GATT and was a founding member, it actually selected as a sort of prestigious to be a developed country rather than a developing country, which then it did try. There were efforts to try and reclassify South Africa as a developing country, and there was resistance from all the major trading partners. But South Africa did achieve some benefits from its mixed characteristics of its economy, and as I said, from the goodwill of the transition, and did get some benefits in terms of trade preferences, and did also negotiate sort of benefits in its liberalization, a slower liberalization over a longer period, because it actually started from a very high bar, the liberalization, and also on its agricultural side, it did receive more benefits, a slower liberalization, and reductions than most other developed countries. So it did get some of those benefits, but of course, as all the trade protection is liberalized, the only safety net left that's WTO compliant is anti-dumping, and that's why there was a commitment to strengthen the anti-dumping system and a greater use of the system by the local industry.
Thank you so much, Leora. I do notice the time, and I'm just going to say to the audience right now, we're going to run a little bit over, and hopefully not too much over, maybe about 10 minutes, because we really want to also give opportunity for Asmita and for Regis. And actually, Regis's discussion talks very much about this development aspect and developing countries, so it's also very important. But Asmita, I'm going to turn to you. If you can sort of crunch your summary, and then we can have a discussion about South Africa's trade policy from 1994. So looking at the administrations of Mandela, Mbeki, Zuma, and then looking at what Ramaphosa has done so far, and sort of what are the defining moments of South Africa's trade policy during that time. So take it away, Asmita.
Thanks, Kholo, and thanks to you and Fan and Olisi for pulling this all together. It was a lot of fun. It was a lot of hard work for you guys too, dealing with us, the authors. So thanks again. And just what I tried to do with this particular chapter was, there's a lot of broad criticism about South Africa's approach to economic diplomacy, that there's no synergy between what the foreign policy says, how economic diplomacy fits into that. And what I wanted to try and do was acknowledge those criticisms, not that they're not valid, they are, but also look at some of the challenges facing South Africa as a country, and drawing on what both Leora and what Justice Unterhalter has said in terms of this dual economy that the country has found itself in since the democratic dispensation, and also this uncomfortable role in many ways sometimes that you see playing out in a multilateral forum. And so what I do in the paper is, or the chapter I should say, is that we first look at issues around economic diplomacy, the different roles between DTIC and DIRCO, and the ways in which sometimes there isn't that kind of synergy to create a cohesive picture that's put forward in the international fora. And what you really see is this tussle between domestic priorities. We have stagnated economic growth, we've got high employment levels, the apartheid transition, and then advocating for African interests at a multilateral forum, and bearing in mind that not all, that many of these roles were kind of self-appointed. For example, South Africa's voice as the African voice in the G20, not something that's necessarily receiving widespread support from the rest of the continent, but the fact is that South Africa is there as the sole African representative. And then, of course, the idea of promoting regional development against the backdrop, as Justice Unterhalter has already said, against a backdrop of really trade balance and trade benefits that are in favor of South Africa as a whole. And the idea that there are these perceptions around South Africa's exceptionalism, the way we have treated our peers from other countries, the xenophobic attacks, that actually doesn't help our cause in terms of being seen as a big brother, and in many ways South Africa being caught between a rock and a hard place, that, you know, if you do something, or if you say something on behalf of the continent, that is you know, you may not be welcomed in that role, but also the fact that if you don't do anything, you are equally criticized for a lack of action, or a lack of stepping in, a lack of using your knowledge, your weight, your force, or your persona, I should say. So a little bit like a United States of America kind of position, not the same, entirely the same cloud, but a little bit the same sort of dynamic that the US faces. And so what the chapter does is that it really looks at the different presidencies with a high level overview of how South Africa started off as a role of a bridge builder, and into Mbeki's presidency, where there's a focus on Pan-Africanism, there's a focus on aligning South Africa to South-South issues, the fact that you have something like the NDB coming up, which is, you know, a challenge to the established order, trying to, you know, which happens under the Zuma reign, and then of course being aware of economic realities, that as much as South Africa is and did align with South-South issues, the fact remained that we were signing the AGOA agreement, that we have the TDCA with the EU, that there's some economic realities you can't escape from. And I think that's what I tried to do in the chapter, is really bring that to the forefront, that there's this aspirational aspect of South Africa's economic diplomacy, and there's also the reality on the ground. Who are our main trading partners? Where do our products go? Where do our services go? And how does the government really balance that kind of disconnect in some ways? And then looking at the Zuma presidency, where you have some sort of heightened trade tension with some of our more traditional partners, but we still signed the economic partnership agreement with the EU. And then finally, Ramaphosa's presidency, where there is this balancing act again that's coming to the forefront between solving domestic economic issues, but as we can see, for example, with the TRIPS waiver situations, clearly wanting to play a role again on that international stage, clearly wanting to be at the forefront of helping to resolve and unblock some of the deadlocks. So that's kind of where I've taken the chapter, and to try and identify the fact that even when they have, and the chapter does talk to this point, even when there have been efforts to harmonize, even when there have been efforts to create policies and implement strategies that brought the two together, foreign policy, economic diplomacy, and the interests of the private sector, of South Africa's private sector, it hasn't always worked out the way it wanted to, and that's not for lack of trying necessarily. So what the chapter tries to do is to highlight some of the regional challenges, like South Africa's economic position in the region, against some of the economic realities facing the country, and then some of the aspirational hopes and ambitions that the country has, and how it still finds itself in a difficult place. And I would just want to give one example. So in the WTO, we know that South Africa votes alongside the Africa Group and is firmly committed to the Doha Development Agenda. But, you know, in the chapter, I put forward the question, well, you know, would perhaps discussing and being part of something like the e-commerce working group not maybe be a better way forward, not to abandon the Doha Development Agenda, but the fact is that for many of the WTO members, the discussion has gone beyond that. And so if we don't want to be in a position where there is no consideration given to what Africa needs, what the continent needs, how something like what is being discussed at the WTO could fit into the AFCFTA, is it not better to be playing a role in that room rather than saying, well, no, this has not been our position for the last 20 years, and so this is the position that we're going to stick to. So yeah, I'll leave it at that, but the idea of the chapter is to bring forward this debate and to try and highlight kind of the difficulty that South Africa faces when balancing national, domestic, regional, and multilateral interests all in the same pot.
Thanks so much, Asmita. And I think you do a really good job. And I think my I appreciated the way that you sort of spell out the policies throughout the presidencies. And I think Leora really brings that to the fore in her chapter as well. And she was speaking about sort of the first decade, from, 94 until, whatever, 2005, 2004, where it seemed like South Africa had positioned itself to be sort of a continental spokesperson, whether self-appointed or expected or, whatever it was. South Africa just said that we're going to take this role. Becky came, as you said, with Pan-Africanism and all of that. But then, things kind of started falling apart. And a lot of the criticism, and maybe, you touch upon this a bit in your chapter where you talk about there seems to be a shift of focus, right? The focus, as you said, was, in the early 90s, or at least mid-1994, there was a flurry of agreements signed by anybody who was willing to come to the door, especially the European partners, bilateral investment treaties, et cetera, et cetera, et cetera. And then we, move later down and seems like, I think we've stepped into places where we weren't supposed to step before. But it coincides with Zuma's presidency. And so it seems like, this is a chapter, this is obviously not a legal chapter, it's a political economy chapter that talks about policies. It seems like there is a shift, but was there really a deliberate shift in South Africa to move from sort of the liberalization darling to, a country that's looking a little bit more sort of inward and also into Africa?
I think this is where the challenge comes in, because as you said, under the Zuma regime, we joined BRICS, although the legwork for BRICS was laid during Mbeki's presidency. And you see these perceived heightened trade tensions like the Citrus black spot incident. We have the poultry incident with the US under AGOA. But then we also sign, the EPA. And we actually, we see a situation where South Africa wasn't allowed to initially join the EPA discussions, and then they do, and they kind of use this. And that's also important, that one of the things that I think we tend to overlook when we look at South Africa as this hegemon or this voice for the African continent is the fact that it is one of the few countries on the continent that has extensive negotiating experience with global powers. So when South Africa steps into the EPA negotiations, there's a change in the tone, there's a change in the structure. There's South Africa is also there to get their own concessions, improve agricultural concessions that were not achieved under the TDCA. But ultimately that, you have this situation where you've entered into a massive trade agreement with one of your large trading partners, and you are still working to shift some of the narratives around the way the global power structures are with the NDB, for example. You don't have to go to the IMF, you don't have to go to the World Bank, you can come to the New Development Bank instead. So, and I think this is where the difficulty has faced South Africa, is that you want to build a coalition of willing southern states and you want to foster those South-South relations, but the way your economic trading partner relations are structured is not always in alignment with the political ambitions that the government might have. And that, I think, is where the challenge comes in. And just as an interlude, I did another project at one point, and I remember there was a lot of upsetness about South Africa being, the AU, when South Africa became the chairperson for the AU. But there were also talks about, when I had spoken to stakeholders in the field at that time, there were talks about information leaking out from the AU at discussion level, like state level discussions, leaked out to partners that were not supposed to have access to this kind of information. And so then South Africa steps in and they're like, okay, well, we're bringing this to a close. Like we're curbing this. This information is getting out. We don't know who's leaking it. We're stopping. And so we're stepping in and we're taking control over the chairperson position of the commission. So it's a very difficult position that South Africa finds itself in. And I think that, until the global South becomes strong enough where we can trade with each other confidently, where we have the mechanisms in place that support increased bilateral, trilateral relations between us, it's always going to be difficult to foster those relations, but not keep an eye on what is happening where your export flows and your import flows actually take place. Yeah, I'll leave it at that.
No, I completely agree with you. I mean, just for your interest, and Asmita does highlight this, I mean, China and the EU remain South Africa's biggest trading partners by far. Also, South Africa is also one of the African countries that trades the most with African countries, especially in SADC. And so there's always this tension between, you know, who am I trading with versus who I would really like to trade with, and who, you know, the people I'm very close to sort of in terms of, you know, ideology, but there's always this tension. And I think your chapter really sort of addresses that very well. Last but not least, Reggie, we're going to come to your chapter, which is absolutely important. I mean, not only, you know, we focused on South Africa a lot, we're moving into sort of the bigger realm of development to developing countries, especially in the WTO. And this is a hot topic right now. So Reggie, maybe in a few minutes, if you could just sort of, you know, summarize your chapter, and then we can have a little bit more of a discussion about these issues of development that are hot and that are burning at the WTO right now.
Thank you, Kolo. Let me first join my voice to the previous speakers to congratulate you, the authors, editors, for putting together these this range of authors to deliver this project, and then thank you for your invitation to participate in this project. My chapter actually addresses special and differential treatment, which is form part of the priorities for African countries and developing countries more generally, and African countries more specifically. Actually, the question of development and special and differential treatment is one of the issues which has actually, at least prevented the WTO from delivering any new agreement since the conclusion of the Uruguay round. As we all know, the difficulty, the stalemate at the WTO is actually around the Doha round issues. Doha round issues has been, or at least was nicknamed development round. And one of the issues around one of the issues at the center of the Doha round is that of development questions. And developing countries actually, chief of which you can see India and China have always resisted embracing new issues until these issues have been addressed in the round. So my chapter actually addresses provisions that were actually negotiated during the Uruguay round to actually take into account the developing countries, the situation of those countries that intended to integrate into the multilateral trading system, and taking their weaker position into account. So basically, I take into account the past, the present, and the future, likely future direction of special and differential treatment. So basically, what I argue is that the past might inform the future. They fought for so long to actually get those provisions in place, and during the Doha round, they are looking for these provisions to be enforceable, to be strengthened, and in the future they have resisting any new agreement that do not incorporate at least some of these provisions propositions that they made during the Doha round. And the chapter also looks at the trade facilitation agreement as a possible template, I would say, of what future special and differential treatment might look like. The trade facilitation agreement is the only agreement that had managed to be delivered by the WTO members since the conclusion of the Uruguay round. And the trade facilitation agreement actually takes special and differential treatment to new heights, or at least adopts a new approach to special and differential treatment, whereby developing countries can only implement the agreements based on their capacity to do so, and they have the right to seek technical assistance and to designate which provisions they are able to implement. So it is now likely that any new agreement that will be negotiated at WTO would at least feature, or at least take into account what has been achieved in that trade facilitation agreement. So this is what I argue in the chapter, to look at an outlook in terms of what the future of special and differential treatment might be. And as you can see, as we all know, the recent challenge around the fishery subsidies, around the fact that some of these agreements cannot be concluded if special and differential treatment are not taken into account, despite the fact that the US and other countries have been challenging the very rationale of special and differential treatment by stating that some countries no longer belong to the category of developing country, and so should embrace rules in a more fully as developed countries. While at the same time, on the other hand, developing countries are saying that the special and different treatment remains relevant, and then that the purpose that they were meant to serve are still relevant today. So, and then we can see that this battle of ideology at the WTO is still going on even today, whereby developing countries hold on to their position, and while developed countries want to move on new issues, despite the resistance of developing countries. So this is basically what the chapters actually takes into account. It actually surveys the categories of special and different treatment provisions and what the challenges that they bring. So yeah, I'm looking forward to our discussion.
Thank you very much, Regis. I think what would be interesting for our discussion is just for you to define or to sort of give us an idea of how developing country status is accorded or awarded at the WTO, and if you can just maybe distinguish that against the least developed country status at the WTO. How does it work?
Yeah, thanks, Kolo. From the beginning of the negotiations of the special and differential treatment provisions, the formula that was chosen was self-selection or self-election. In terms of any member that joined the GATT or the WTO later would self-elect and self-select as developing country, and that, of course, that status can be challenged. But that was the formula that was actually decided upon, and the reason was simple then. Some of the countries were OECD members back then, and then the formula was chosen not to exclude those of these countries that believe that they needed to benefit from this provision. You have some OECD countries like Spain, like Israel, for instance, who actually sought to benefit from the special and differential treatment, one with that self-selection formula. And it is even challenged, or I would say, it was even controversial that today that same people who actually, or same countries that actually put in place that formula of self-selection are the ones who are challenging the same formula today that's benefiting developing countries. If you know, the US, for instance, is now challenging the self-selection formula. Meanwhile, it did not challenge, did not dispute that fact when it benefited other countries, but when it was when the provisions were being negotiated. So the formula is self-selection, and any country that believes that its economy can only support a certain level of the economic development can self-designate as a developing country and then benefit and seek to benefit from special and differential treatment in the WTO. Now, the LDCs, as you know, are the countries that are designated as such by the United Nations in a specific list by the United Nations. And this is even included in the WTO agreement. But again, strangely enough, we see that the United States, for instance, has somehow altered his list of LDCs when it actually decided to exclude some countries from its developing country in the trade remedy law, by moving some countries from the developing country, self-selected developing country, to the list of developed country, but also moving some countries in Africa, like Nigeria, that have decided to be developing country, to the list of LDCs instead. And so unilaterally modifying the WTO agreement without consensus. So this is kind of some of the issues that basically that define the challenges around the special and differential treatment in the WTO currently.
Regis, maybe you can briefly just speak to those criticisms that, the more developed countries are leveling against, countries like even South Africa. I mean, in the US subsidies or, countervailing measures, investigation, South Africa has been excluded from developing country status because it's a member of the G20, for example. There's other matrices like share of world trade, And I think it's also, GDP per capita. There's a lot, sort of a few matrices that the US has chosen to sort of designate countries as one or the other. So first of all, maybe you can address what are these sort of challenges that the more developed countries have? And secondly, what is it that the more developed of the developing countries, because not all developing countries are equal, in the category of developing countries, we have countries like Singapore and South Korea and Hong Kong, and of course, China. And then, of course, we have countries like South Africa, we have countries like Nigeria, we have countries like Senegal, et cetera, all, the Latin American countries. So what has been the response from the more developed of the developing countries to the criticisms that the US and other developed countries have leveled?
So yes, of course, you're right that not all developing countries are the same level of development, of course. And you have more, the world economy is not the same like it used in 2021, like it was in 1994 when the WTO agreement entered into force, or like 1995 when it entered into force. And one of the criticisms exactly that the US actually leveled against some countries, or China principally, that it has taken more stake in world trade, that it no longer belongs to the category of developing countries. Actually, might be not everything that the US says is bad or should be thrown away, right? Because there are exactly few countries in that self-declinate as developing countries that have actually taken. Been participating in world trade at the same level as developed countries. But again, in developing countries, there are some countries that are developed in some sectors and not in other sectors. So this is also very difficult to differentiate which kind of sectors in which some countries can actually be categorized as developed, and in other sectors categorized as developing. So it's very difficult to establish a criteria to actually make that happen. So the self-selection formula, which is now being challenged, and an objective criteria of who is a developing country these are very the dichotomy around that. I mean, it's very difficult to actually, or the solution is difficult to achieve in that regard, because if you are to put a objective criteria of who is a developing country, then you might end up with the endless debate that you all know, whether developing country, whether the WTO should be that development organization. So, but the formulas chosen by the US, for instance, the GNE per capita, the participation in the G20 as a criterion to move from a developing country to a developed country, is exactly what some of the developing countries are resisting. They are saying that some countries that the special development is the most important, I would say, driver of inclusion in the world trade, with the multilateral trading systems, and so much so that it is not upon the US or any developed country to actually challenge that fact, and that if some countries have already achieved some stake in the developing in the world trade system, in the WTO or in the world trade international trading system, not all of them have actually achieved that status, and that instead of trying to discount the importance of these provisions, that what WTO has promised to deliver to developing countries should continue. That is, strengthening these provisions to make them more enforceable, or at least to serve the rightful purpose, to bridging the gap between those who are developing and those who are developed, so that the world trading systems can be more inclusive. So this is what is actually at the debate, and what actually the chapter actually addresses.
Okay. Thank you very much. We've really passed the time that we have allotted ourselves for this webinar, but we really wanted to give this opportunity for this engagement and debate, and we thank you very much to our authors, and of course we thank Justice Unterhalter for his opening address. We do note, Gustav, your question, and we Fortunately, will not be able to address it because it is quite an extensive question that needs an extensive answer. But if you want, we'd be happy to sort of give you our comments in writing if that's okay with you. And so on this note, we're going to close this first webinar. Thank you very much for your participation. Thank you for your patience. Thank you for coming in, and thank you for your engagement. I hope that today's discussion gave you a flavor of what are the topics that we're discussing in this book. And of course, these topics, today's topics, are sort of more umbrella ones when the rest of the book is going to be sort of a little bit more legal, I guess, in stance. So please join us for the next webinars. Next one is on the 16th of September. The other one is on the 21st of September. The 16th of September, we'll be talking dispute settlement, decision-making, competition, and the AFCFTA. And in trade remedies, we'll be discussing, obviously, safeguards, anti-dumping, and subsidies. So thanks again to our authors. Thank you for agreeing to take part in this. And thank you also to Justice Unterhalter for opening. And have a good evening. Bye-bye.
Thank you,
everyone.
Cheers.
Thank you.
Bye-bye.